Well, good morning, everyone. We have the honor today of having Edith Ramírez, who you all know is a former chair of the Federal Trade Commission and is the current head of the antitrust practice at Hogan Lovells. And she will be speaking about recent trends on U.S. competition enforcement. So, Edith, without I'll put the presentation.
Gracias, Julián. Antes de empezar, voy a dar la plática en inglés, pero les quería dar un gran saludo en español antes de empezar. Mucho gusto estar aquí con ustedes.
Gracias.
Igualmente.
And Julián, thank you for helping me with the presentation. If you could put it in presentation mode. So again, delighted to be here with all of you. So I'd like to focus my discussion this morning on a couple of main topics. Recent developments is a fairly broad topic to cover, so I thought it would make sense to try to hone in on a couple of areas that I find to be of particular interest. And mainly, I think there are good lenses through which to look at the mission as a whole of the antitrust agencies under the Biden administration. And in particular, I wanted to focus on these two topics because I think they're examples of sort of important objectives that the agencies have. Generally speaking, of course, we've seen a very expansive view of the role of antitrust under this administration. There's some deep skepticism about consolidation and, frankly, an effort to try to halt consolidation, both substantively and I think procedurally at the agencies, and trying to use all of the tools that they have at their disposal in order to do that. We also see broad theories of harm and novel theories of harm being examined and explored, and skepticism about remedies, and also an increased appetite for litigation. And I think that the focus on labor markets in particular is certainly reflective of this very expansive view of the role of antitrust. And in particular, I think one of the underlying thinking that is reflected in the leadership at the agencies is the need to have antitrust really endeavor to address what are seen to be very deep and important socioeconomic issues, and income inequality is clearly one of those issues. So I think the focus that you see today is very reflective of that. There was certainly attention to labor markets in the past. That was an issue that was of concern to us in the Obama administration, but there's been the current administration has certainly taken that and greatly expanded that focus. I also thought that a dialogue about AI and competition, and in particular advanced AI and the developments that we've seen when it comes to generative artificial intelligence, is also another topic that I think is important to keep an eye on, because it's an area of such that is so fast moving, so dynamic. And as we see, not only we see in the US, but also, of course, in other jurisdictions, antitrust enforcers are deeply concerned about developments in this area, the competition impacts. And I think they come at that topic with a mindset that where they've learned from the past, they're concerned about the fact that and have a view that competitive issues relating to digital markets weren't fully appreciated, and there wasn't enough action taken to address those competitive impacts. And so I think they really are poised, I think, to act very quickly when it comes to issues relating to advanced AI in particular. So I'd like to touch on that topic. And then I'll just highlight at the end some cases in the digital arena and the big tech arena that are going to be important to keep an eye on. And I think this year in particular, we'll see some outcomes that'll be very interesting to see, and I think might be useful topics for a future breakfast with the ForoCompetencia. So with that, Julian, if you could go on to the next slide. So starting with labor markets, we've seen real, again, focus on labor and the new 2023 merger guidelines, and also the proposed HSR rules really reflect this significant deep interest and focus on labor. The proposed HSR rules, which we expect, based on what we've heard in recent weeks, we expect those to be finalized in the near term. Those rules will require, assuming there aren't any changes, will require information in every filing about the largest categories of employees, and will also require information about the geographic areas where those employees are based, as well as information about past labor violations going back 5 years. So this is going to be a very significant change, contrast to the past, where the agencies might have looked at labor issues if they felt that they would come into play. Now it's going to be an issue that's going to be examined in every single case. And interestingly, in the merger guidelines, the agencies have made clear in the discussion relating to buyer power that they're going to be looking very closely at whether the proposed merger potentially substantially lessens competition for workers, and they'll be focused on the ability of the merged entity to lower wages or slow wage growth, or also degrade the working conditions of employees. Notably, the merger guidelines emphasize that if there is an impact on the buyer side, that is not something that can be offset by any efficiencies that might be available on the sell side. So I think the way that this plays out is going to be quite interesting. And I'll note that we've seen certain settlements that the FTC has entered where they endeavor to address issues that relate to labor. On the DOJ side, in the Penguin Random House, Simon & Schuster transaction that was successfully blocked by DOJ. In that case, the DOJ very much cited the effects that the proposed merger would have on compensation for authors. And so I think we've seen cases where this issue has been addressed. A very interesting upcoming case that I'm keeping an eye on is the proposed merger of Kroger and Albertsons. In that matter in particular, it's very interesting because one of the negative impacts that's been cited both by the FTC as well as states that have also sued to prohibit that transaction is the ability of unions, the impact on unions and union labor in particular. And the argument is that the proposed merger would end up reducing the ability of unions to play the two firms off against one another during labor negotiations, because those two firms are among the largest employers of union grocery labor in the United States. So I think that it still remains to be seen exactly how this issue ends up playing out and the importance that it'll end up having. I think the Kroger-Albertsons transaction is one that I think will be quite telling. And we'll see if the court ends up finding that set of issues compelling. So that's certainly one transaction that I'm keeping an eye on, and that could really, if the court adopts the approach that's being taken on that, in that line of argument, I think that'll be a very interesting development. We've also seen the Department of Justice expand its focus on criminal prosecutions of no-poach and wage-fixing agreements. Of course, no-poach agreements are agreements by firms not to solicit or hire employees. This was an area that was of concern back in 2016 during the Obama administration. That was when both the DOJ and FTC, we issued guidance in this arena, and DOJ conveyed its intention to prosecute these agreements criminally. DOJ brought its first criminal case in 2020, but the results in court have been quite mixed. There have been some successes. DOJ did get a ruling in the DeVita case where the court held that a no-poach agreement is a type of horizontal market allocation and therefore would be per se illegal if it can be proven. But there have also been very significant losses. DOJ has not succeeded in persuading juries to criminally convict a defendant for alleged no-poach or wage-fixing conduct. So DOJ has lost 4 trials in this area, and then at the end of last year, also voluntarily dismissed a case that was on the cusp of going to trial. So that's been an area that has had at best mixed results. Nonetheless, it's DOJ and the FTC have made clear that they're going to continue to be looking hard at this type of conduct. Another development that I have found interesting is that the FTC has entered into memoranda of understanding with both the U.S. Department of Labor and the National Labor Relations Board. The goal of these MOUs are to share information and also potentially to utilize the expertise of these agencies in connection with potential investigations. But I think this is just another step, another tool that they're using, again, highlighting that these are going to be issues that are clearly going to be closely scrutinized, both on the merger side as well as on the conduct side. Julian, if you could go ahead and move to the next slide. And then, of course, just recently, the FTC has announced that it has and issued the final rule banning employee non-compete agreements. The rule prohibits virtually all non-compete agreements, and in addition, it requires employers to rescind existing non-compete clauses, and also to requires companies to inform employees that they are void. There was certainly significant concern about employees not understanding the law. I live in California, which is a state that has already outlawed and prohibited non-compete agreements. But oftentimes you have situations where workers are not fully informed of the law. So for the agency, it was important to have that notice requirement. It is a rule that is if it does come into play, and I'll get to the litigation challenges shortly, is going to have significant impact. The FTC estimated that non-competes affect 1 in 5 employees in the United States. The rule really is virtually a full ban. It has a narrow exception for current non-competes for senior executives, but it does ban future non-competes, even for senior executives, and non-competes that relate to the a transaction involving the sale of a business. Those are permissible. The rule has been quite controversial. There's a lot of sympathy policy-wise, in particular when it comes to non-competes that impact low-wage workers, because the justifications that are used for such non-compete agreements typically include the protection of trade secrets, the investment in training. Those justifications are less weighty and less convincing when it comes to low-wage workers, and the non-competes are used quite widely. At the same time, there's significant skepticism that the FTC has the appropriate statutory authority to issue the rules. The FTC has clear authority when it comes to the consumer protection arena, but there's been a long debate that dates back well before the current administration about whether the FTC has the authority to issue rules in the competition arena. And so there's some support for that, but already there have been numerous lawsuits that have been filed challenging the rule, which was slated to become effective 120 days following its issuance. But we'll see how the litigation plays out. I think the conventional wisdom is that the rule, certainly in its current form, is unlikely to pass legal muster. That remains to be seen, but I think given the breadth of the rule and the fact that this is an area that has traditionally been governed by state law, I think the prevailing wisdom is that the rule is unlikely to see the light of day, at least in its current form. Nonetheless, that I think this is an absolutely very significant step by the FTC, in my view. Putting aside the final contours of the rule, I think it was an important step for the agency to take to test whether it has that authority, the authority to issue rules in the competition arena. So I will go ahead and move on to AI, but labor is, again, clearly an issue that's going to continue to be a priority for both agencies. And I think one that will be, as we move forward, will be an important test in terms of the overall impact that this very expansive view of what competition should do in society and the impact it can have. I think this issue is going to be one to look at closely to see how it continues to develop. I also wanted then to, and I'll turn now to AI and competition. I know that you all had a very interesting talk earlier. I forget exactly when that occurred, but before, so I won't spend too much time on this. But again, I see this as another important issue, especially when it thinks about advanced artificial intelligence and how the agencies in the U.S. will address this set of issues, given the view that that there was significant under-enforcement in connection with digital markets. I think they'll seek to act quickly, and we've heard a lot from them on these topics, but still remains to be seen exactly what might happen on the enforcement front. But I'll just highlight a few of the key issues here. Clearly, a central concern for the agencies relates to the structural dimensions of the development of advanced AI. There are very few number of players that have control over the critical inputs that are needed in order to develop foundation models. And we're of course looking at, I won't go into much detail, but of course computing power, computational resources are very scarce, and can be a very significant bottleneck when it comes to the training of large-scale AI models and the deployment of those models. And there are just a handful of companies that have control over those resources, the chip designers, the chip fabricators, and of course, the cloud infrastructure firms. Data, another key input. Without data, there's no machine learning. And of course, generative AI and other advanced AI require extraordinarily large data sets. So there's also a very clear, distinct focus on that set of issues. And then the specialized labor that's needed in order to develop foundation models. You need AI engineers with highly specialized knowledge to develop these models. I know that there's certainly in the tech world, engineers and other technologists are racing to get themselves up to speed when it comes to these issues, but at least so far, it certainly requires very specialized knowledge. So in order to access these resources, small innovators are partnering with large players, and that's an area of deep interest and concern by the agencies. And in January of this year, the FTC launched a study to assess the competitive impact of collaborations that we've seen between large tech firms and AI labs like OpenAI and Anthropic, among others. Of course, there's broad interest in this around the globe. We see this similar interest, and we see investigations in the UK at the CMA, and also by the EC looking at the Microsoft OpenAI relationship. But that's certainly going to continue to be something they look at very closely. They're going to be interested, of course, in examining the extent to which these collaborations might impact head-to-head competition, the extent to which these types of collaborations or investments might lead the large tech firms to steer in favor of their own products. They're also concerned about, of course, potential unlawful exchange of competitively sensitive information. And another area that they're significantly interested in and has been reinvigorated under this administration has been a focus on guarding against overlapping directorates. DOJ in particular has made clear they're going to be on the lookout for situations where you have members of the board of directors of two firms where there might be competitive impact. So again, we've heard a lot about what the concerns are so far. But again, still remains to be seen exactly how this plays out. But I am of the firm view that we're very likely to see them to see that both agencies take prompt action where they feel they have the ability to do that. Julian, let's go ahead and move on to the last set of issues. I also wanted to touch a bit more broadly with regard to AI in particular, not necessarily specific to advanced AI. There are, of course, some important issues that come into play once you get into issues that relating to self-learning algorithms. But there's a number of cases in the US right now, both in the private litigation arena, as well as investigations that have been publicly reported, and also lawsuits that implicate issues that relate to algorithmic pricing. We've seen, of course, increasing use of pricing algorithms across the economy, and there is very significant concern about the use of algorithmic decision-making to make pricing decisions, and concern about whether the algorithms might be used both to potentially collude, also concerned about the use of in particular, third-party vendors and third-party software solutions that aggregate data and make pricing recommendations. That I think is the scenario that is really the subject of significant litigation. In the rental housing sector, there's also some litigation in the hotel booking sector, the food sector. These involve third-party software solutions that collect information and then give pricing recommendations. And the DOJ has been quite vocal about about current concerns and investigations that are addressing these issues, concerns that these might be used both to again, exchange sensitive information, non-public information, but that might also be used for purposes of facilitating price fixing. There are, I think, significant complexities in order to establish the existence of an agreement across firms. The theory that's being used is, of course, a hub and spoke conspiracy. I think it'll be very interesting to see how those that litigation plays out. The DOJ has submitted statements of interest in various litigation matters. Most recently, they filed one along with the FTC, highlighting to their interest in the matters to the court and noting that in their view, there are a number of ways that agreements can be established. I think the issues are quite complicated, and showing agreement can be difficult, I think, in this area, and of course the firms involved and the third-party vendors involved soundly reject the idea that there's price fixing occurring. But I think those looking at those issues in those cases, once they play out, I think it's going to be very interesting. Another set of more complicated questions arise when you have parallel conduct where there isn't an agreement. I think those are areas of concern as a policy matter, but of course the challenge of demonstrating agreement is going to be something that will just simply be an obstacle in terms of the ability of traditional antitrust doctrine to reach some impacts that are very much akin to collusive conduct, but where you have algorithms that are really enabling firms to follow the lead of others in real time, and therefore have much broader impact than that type of conduct had in the past. And then, of course, you have the situations involving the potential for algorithms that learn on their own, and where even without any form of human involvement, any form of agreement, have the potential to lead to collusive impacts. And there's a lot of studies, of course, that I'm sure you're all at least aware of some of those studies that show potential collusive impacts that arise simply from machine learning. I think these are issues just to keep an eye on. They're ones that are not new, but are going to become more relevant, again, given the widespread use of algorithms that we see really across the economy. And then finally, I wanted to just turn very briefly to highlight some various cases that are currently pending, ones to keep an eye on. I won't go into them at length, but I really think, again, Juliana, a suggestion for topics for future breakfast. The search case against Google, US v. Google, it's litigation brought by DOJ and also a number of different states. The closing arguments took place earlier this month in that matter, so there should be a ruling forthcoming in the coming weeks. It's very complicated, complex case, remains to be seen, of course, how the judge rules, but that's going to be, right, it's seen to be just an incredibly important matter, most important Section 2 case, right, since Microsoft. Also pending and is the FTC case against Facebook. And I'll note that both the Google case and the Facebook case were initiated by the last administration and have been carried forward under the current administration. That the Facebook case has been pending now since 2020, after the initial complaint that had been filed by the FTC was dismissed. They were permitted an opportunity to amend that complaint. That's the case where the FTC seeks to is challenging prior acquisitions, among others, the WhatsApp and principally the WhatsApp and Instagram acquisitions. So again, another case to keep an eye on that likely will take longer than this year to play out, but that is moving forward. Last fall, the FTC brought a very broad case against Amazon. That one is still in its early stages, so that will take, I think, years to play out, but another one to keep an eye on. And in that particular case, the FTC has alleged anti-competitive conduct in two markets. One, the online, they call a superstore market that serves consumers, and then the market for online marketplace services that are purchased by sellers. And then finally, it's also been publicly reported that DOJ is in the last stages of a very significant investigation against Apple, and that they're looking at strategies that Apple has employed to protect its dominance with regard to the iPhone. So the public reporting is that is a matter that could another either lawsuit, and unless of course there's some type of settlement that might be reached, that could be announced in fairly short order, but certainly it's expected this year. So important cases in the so-called big tech arena to keep an eye on, and we'll have very important developments once we see those play out. And certainly in particular, the Google case is something that we will definitely see this year. So I wanted to stop there. Again, I think I just wanted to simply offer a few thoughts and on some recent developments in primarily these two arenas that I view as good lenses to use to really examine the approach and that the U.S. agencies are taking, the very active and aggressive and expansive approach that they're taking today. And also, I think that will tell us a lot about what impact this very expansive view and aggressive view of antitrust might have in the long term. So with that, I'll pause for questions, but also have hopefully a conversation with you all.
Thank you, Edith. Great presentation. And now I open the floor for anyone who wants to. You have Carlos Mena. Carlos, the floor is yours.
Muchas gracias, Julián. Gracias, Edith. Thank you very much for this great presentation. Very early presentation for you. Thanks for that. And I just wanted to ask about the possibility of a new Trump administration, and specifically what you think will happen with all these cases that you mentioned at the end, and the charge against technology companies. Do you think the cases can change, and the agenda for the new administration, if you have some views? And thanks again, Edith.
Sure, Carlos. Yes, we have this looming election in the U.S. Carlos, I think that when it comes to the matters against the big tech companies, I think there may well be some changes in the way that certain of the cases are handled. In particular, perhaps, I think the framing of the Amazon case would be one example. But frankly, and I noted earlier that two of the cases, the Google case and the Facebook cases, were started under the Trump administration. There's been, as I think you're all aware, right, bipartisan concern expressed about the dominance of the large tech firms. And so I think that in some form or another, I don't believe that those cases will be dropped. I think those will continue. In my view, the very broad complaint that in Amazon, I think that it's conceivable that one might be handled differently. Remains to be seen what happens in connection with Apple. But I think that in particular, the concerns surrounding Google, for example, are ones that I think are is likely to continue, in my view. The contours and the shape and the way that might play out, I think could change, but when it comes to an overarching close scrutiny when it comes to digital markets, I think that is likely to continue. That being said, I think a lot of what the current administration has done is likely to go and fall by the wayside. Things like the rulemaking, competition rulemaking, are issues where I think the serious concerns about the authority of the FTC to issue broad rule like the one that's been issued, that is something that I absolutely don't think you will see in a Trump administration. I think you will. I think the merger guidelines that came out at the end of last year, I think those are likely to be revisited. So there is a lot, I think, that unfortunately, will be completely redone. I say unfortunately in the sense that so many resources have gone into putting out this new vision, but the reality is that there is a lot there that I think would end up likely to be withdrawn and redone. But when it comes to the core of the concerns about digital markets, I think you're still going to see very, very active. You're likely to see very active work by both agencies, in my view.
Thanks so much, Edith.
Esteban?
Sí, thank you. Maybe two connected questions. One is, what do you think are the probabilities of new legislation acts regulating digital platforms and digital economy? And if you have any prior about how the courts will deal with these cases, especially with these maybe new theories of harm or reformulated theories of harm, and especially with this view of great weight given to the structural issues and the concentration of markets by this administration. Thank you.
Great question, Esteban. So let me start with legislation first of all. I think there's, in my view, and I'm not an expert when it comes to our Congress, but I personally don't see our Congress having the wherewithal to really pass legislation in this area when it comes to how to handle some of these issues relating to advanced AI. I think the US will continue, as it has done, to lag behind what is happening in Europe. And so in all of these arenas, I'm highly skeptical that we'll see anything get through our paralyzed, Congress. Only until there might be a small chance to finally get federal privacy legislation in the US with the American Privacy Rights Act legislation that was put forth recently, but I am skeptical that they'll do much of anything when it comes to competition. And so I think the US we'll be looking to see how things play out in Europe with the Digital Markets Act, and frankly, we'll just continue to lag behind when it comes to dealing with very significant issues that advanced AI poses on a number of different fronts. With regard to the courts, it's a really terrific question because the agencies have had mixed results when it comes to how the courts might embrace some of their views. So I think it'll be interesting for me to see how, in particular, as one example, the 2023 merger guidelines might be utilized in upcoming court cases. I highlighted Kroger-Albertsons there on the labor issue. That's just one issue, but it remains to be seen. I think some of the more aggressive stances and aggressive vision, I think courts will be skeptical. One of the successes, I think, of the 2010 merger guidelines was that courts did embrace those guidelines and did utilize them. I'm a bit more skeptical that that'll be the case with the current guidelines. So I think it will be the clear test in terms of how the agencies do in court. So I think that it'll be challenging. I think some of the aggressive stances that the agencies have taken, I think will not likely to see the type of adoption that we've seen, at least with the 2010 merger guidelines.
Thank you. Thank you.
Eduardo.
Sí, gracias, Julián. Edith, es un gran placer volver a verte por acá y gracias por esta excelente presentación. So let me move to English, given that Terry, my good friend, is going to get mad on me. Edith, in the case of Mexico, this is an issue basically of competition among unions. In the case of Mexico, the Constitution basically prohibits the antitrust authority to enter into that area of unions in general. There has been a long time concern in Mexico because there are suspicions, just to say the least, that many of the leaders of union leaders basically collude with the administration of the companies, damaging in some cases just the union negotiations with those companies and affecting negatively the workers. What is interesting, and this is I just wanted to hear your reaction on this. In the case of the free trade agreement between Mexico, US, and Canada, during the renegotiation that took place that started with Trump, but ended with Biden, at the very end, with the Biden administration, it was introduced basically an article that opens competition among unions within the companies. So this is quite unique, and there is a special kind of dispute settlement mechanism that is already in the agreement. So I would like to hear your comments, because this is a case. This is a very good example where free trade negotiations introduce a very important competition element in a specific area, like unions in this case. Thank you very much for.
It's a good question. This isn't an area where I confess I don't have nearly as much expertise as you do. I guess so I can't really speak to the specifics of what you're discussing. I think what I will note is that I think the situation here, right, in the U.S. with regard to unions, the presence of unions is so weak in the U.S. There's been, I think, in recent years, some invigoration of union labor and the importance of unions and some success in unionizing workers. But here in the U.S., it's there really are, frankly, just as a general matter across the country, I think it's quite weak. So I think I will certainly be interested to see how by the agencies, how this current focus on looking at labor violations as an example, how that might play into the dynamics and merger enforcement. But I'm afraid I can't speak to expertly to address your specific issue.
Thank you.
Alfonso.
Hola, muchas gracias, Edith, por la interesante conferencia. I wanted to ask you, because we are dealing in Europe with some cases related to the enforcement of competition law to sport, and because there are new players that are trying to enter into the market, but there are issues with regards to how the sport works and how it should be organized. And I would like to know if there is any development in the U.S. in this late months. If there's having any news on this, on how antitrust is going to be applied to those cases.
I think this is another area. I haven't delved too much into this arena, Alfonso, but it is an active area when it comes to antitrust. I think the most recent biggest development that we've had in the U.S. has to do with the compensation of college athletes. And so that's an area where there's been significant interest and antitrust competition-related arguments that have led to that development. I don't know, Terry, you might be able to answer questions about this arena, but I will say, Alfonso, I have a colleague who is quite steeped when it comes to issues that relate to competition and sports. I'm afraid I don't have too much expertise in that arena, but I will say it is an active area. The biggest development that has been this development with regard to the handling of giving compensation to athletes. I think that's been the biggest development that we've seen in the U.S., but there are other sets of issues, Alfonso. I'm happy to direct you to writings that might be relevant on that topic.
Okay, thank you.
Mariana.
Thank you, Julian. Thank you so much. This is an amazing, very insightful presentation. If you had a crystal ball, what would it tell you with respect to where we will be regarding international cooperation and cartel enforcement in 5 years?
Here's Mariana. I mean, frankly, I guess I'd be interested in posing the question to you all, how you all feel about that issue. I think I'd be interested to hear from you all what impact you think that the current view and messaging that we see coming out of the U.S. agencies, what impact that has had on your jurisdictions. With regard to cooperation, I think cooperation has not been from the, in my view, in recent years. I think there's been a bit more, there has not been as smooth cooperation as I think one would want, ideally from a antitrust enforcer perspective. But inevitably, I think on all of these issues, antitrust has been for decades now. It is a global issue, and I think the agencies understand that, and I think that they, well, perhaps personalities might get in the way of the smoothest cooperation at the top. I think at the staff level, there's very deep connection, and I think there is significant cooperation at the staff level, and I think that's only going to increase, and I think it has to increase because the issues that the agencies are dealing with have global impact. They're quite complicated, and I think that the agencies have to continue to endeavor to learn from one another. And so I think my hope is that it'll that at the staff level in particular, it'll continue to be deep, even if at times over the course of the last two administrations, I know that there have been some tensions. But I would be interested to hear from some of you, what you think the impact has been of the developments that we've seen in the US under this administration, and what impact that has more broadly.
Well, to start, I think that we have opened a Pandora box. Basically, we have most Latin American countries have followed the US model, and even Europe has followed the US model. And so the debate on what the goals of antitrust are have been predefined, and basically the message is forget of what we have told you in the past 4 years. This is completely wrong, and now we can basically use antitrust to deal with different social issues, and that has been, in my view, sending a dangerous message to the rest of the countries that have not adopted antitrust out of conviction, but out of different needs that were not related to antitrust, either a free trade area or financial relief. So I think that the going to your question, it is like watching a discussion on at the Vatican on whether Jesus existed or not, and if you are not convinced of what you have been preaching for the past 4 years to the region, what's left for us? And the fact that with just an election, things can change one way or the other. It is a scary thought. I don't know if anyone else agrees or not.
Well, I fully agree. I think, but we see that there is the ICN is very active, and that the ICN has done a great job of convincing everyone, agencies across the globe, of the importance of convergence and collaboration. So it cuts both ways, right? We've been going on one path up until very recently, and now convergence is convergence to different standards. So it's yeah, I think I'm not to sound too pessimistic, but I tend to echo what Julian said. With respect to collaboration on international cartel enforcement, we've been hearing from many agencies that it's picking up, that there have been an increase in leniency applications, and number of dawn raids have increased. I haven't seen that. Hopefully it will come down to Brazil sooner rather than later, but I haven't seen that. So I'm not sure how to separate like the messaging and what wishful thinking from what's actually happening in practice.
I also agree. I think in Latin America, also with not so strong institutional arrangements, open the, as Julian said, the Pandora box of goals to antitrust law or competition law enforcement could be dangerous. So I agree.
Yeah, that is also my sense. So I think at the end of the day, certainly the messaging and the rhetoric has been so vocal and so critical of past work. I think that's been unfortunate, but I do think it will. I think you will see whether it's this November or it's some future time when there is a change in administration. I think you will see, unfortunately, just a lot of a very significant change in terms of overarching approaches to antitrust in the U.S. and what but something that I don't think is good for the overarching and progression of antitrust to have these major and significant swings back and forth. But I think that'll happen for sure. Whether it's my hope is that it doesn't happen in November, but at some point when there is a shift, undoubtedly you'll see efforts to pare back substantially what is occurring right now.
Well, I have a general concern, Edith, that goes beyond of what could happen in November in the US and goes beyond to Latin America. I think the general, I would say the generalized movement towards populism and the lack of interest in markets in general is a major concern. And I think that we have to rethink of what the ICN should do in the next few years. I think the ICN has been very successful in terms of informal exchange of information. There has been a general convergence among a group of agencies, but I think we have to. I mean, the ICN will have to show more leadership in the defense of markets, and I think because I don't see any other international organization being better qualified for doing that job. So I think we have to rethink about how the ICN should move in the next few years.
It's a point well taken, Eduardo. I think that the challenge is how not to overlearn lessons about and mistakes that might have been made with regard to the handling of digital markets. And so how do you approach the current state of the economy? How do you approach it in a way that makes sense, mindful, of course, of now that we have the benefit of hindsight and seeing how digital markets have evolved. How do you not overlearn some lessons from that era? And I think that's the challenge in finding an appropriate way forward.
Anyone else? Oh, then Edith, could you please give us your concluding remarks, please?
Yeah, well, nada más, mucho gusto estar con ustedes. Es siempre un placer ver a tantos amigos y también caras nuevas. Espero poder continuar esta plática. Muchas gracias.
Un gran gusto, Edith. Muchísimas gracias. Y bueno, los espero todos. El mes que viene tenemos una entrevista a Jorge Bloomberg, que lo va a entrevistar Ivo Gagluffi. Así que eso va a ser en junio. Ya mandaré la invitación. Bueno, muchas gracias a todos. Bye, Edith. And thanks for coming.
Hasta luego.
Muchas gracias.
Gracias, Edith.
Hasta luego.
Hasta luego.
Muchas gracias, Edith.